Hello and welcome to Legal Basics with Sarah Law Global, and my name is Ian. So, still on the labor law and employment issues, today we're going to look at the court process. Something has happened. You've not been able to resolve it, you've not been able to talk about it, and now you have to go to court. So, to lead us through this process, today we have a labor law expert. I will let him introduce himself.
Thank you, Sian, and hello, viewer. My name is Isaac Kiche. I am an advocate of the High Court of Kenya with 7 years experience. I specialize in labor law. Beyond that, I am a mediator and also arbitrator. I'm a senior associate at the firm of Triple OK Law Advocates, which is a firm dealing majorly in dispute resolution and has a practical experience of more than 18 years. So thank you very much.
Karibu sana, we're clearly in good hands. So now, Mr. Kiche, what are some of the things that would make, or the grounds that would make an employer or an employee have to go through a court process regarding labor matters?
Thank you, Sian. There are various reasons which can make an employer or an employee to go to court. But mostly, you'll find many of the cases are filed by the employee. And the reason would be if you've been terminated unfairly or you've been summarily dismissed. So you'll find the law allows you to now approach the court and place your grievance before the court so that the court can make a decision. But beyond that, there is instances when even the employer can lodge a claim with the employment court. So for instance, if the contract had provided for a notice period and the employee just leaves without giving that notice, then the employer is allowed to sue the employee to recover that amount. But maybe before we go into those circumstances, it's also important just to point out at the beginning that there are key issues that an employee or an employer needs to know before you venture into that process. Now, on the part of the employee, the first thing you need to know is where are you taking the dispute? And the second thing is when should you take the dispute? And finally is what will you ask in court or before the labor office? So those three are very important. So just starting with the first one, where should you take your claim or this dispute that you have with the employer or with the employee? Now, the law allows various avenues, but principally or majorly, you could either go through the labor officer or you can go to court. So there are instances when when you can go to the labor officer, especially if the dispute is not one that really it's contested so much by the employer. Let's say it is a matter of computation. You are not agreeing on how much. So you may prefer to go through the labor officer because of the expertise that they have. They could assist you with the computation and then they make a recommendation that you should pay this much. But even if you go to the labor officer and you don't agree, it does not prevent you from lodging your claim with the court. But you need to always be alive to the fact that there's a time limit when you should be doing all these things. So for instance, if it is about termination, whatever you do, you should always be mindful that you should do it within 3 years after that termination has occurred. So that is something that you need to be very keen about, because if you don't do it within that period, then you are locked out. So when you want to lodge your claim, so you need to know right now, because of what was witnessed before, there was an availability of many courts to deal with employment matters. So what the Chief Justice did, the retired Chief Justice David Maraga did, was to give a notice to empower even the magistrates court, the resident magistrates courts, to hear employment disputes. So this is in a way of trying to make the justice to be accessed by so many people.
Okay.
So if you are being paid an amount which is 80,000 and below, then you are allowed to go to the magistrates court. So that's what would guide you in where to go.
What to file.
So if now you've decided to go to court and you're within this 3 years period, then you need now to think about, what will I ask the court to give me? Because in our system, the court has to be impartial. The court will not assist you to tell you that, Sian, you need to ask for this, because if the court does that, then the employer might be aggrieved and say that there's an element of bias.
Sure.
So you need to know what you are going to ask the court. So, for instance, if it is termination, you need to ask about if you are not paid the notice period. If there are any leave that were due which were not paid to you, you need to ask for those. Then eventually you need to ask for the compensation, which the law has put as 12 months. It's always advisable to ask for the maximum, because the court has the authority to reduce that amount depending on the circumstances under which you are terminated. So I would say that really, in short, is what would actually guide you when you want to pursue your claim in termination.
So now, some people are not able to afford an advocate, and they have to file their own claim. So what are some of the most critical details that either an employee or an employer who approaches the court for relief should include in their claim?
Thank you. And that really goes into, making sure that the case you present before court is one that can succeed. In fact, usually it's said that most of these cases, you win them at the point when you are making these papers that you want to present to court. Sure. So there are key ingredients that you need to put in your claim. In employment disputes, there are two things that you need to prove. If you are the employee, number one is that the employer did not have a valid reason to terminate you or to dismiss you. And secondly, that the process which the employer took to terminate you was not fair. Now, those are what I would call the guidepost, or the foundation that you should actually base your claim on, those two. Now, when you come to drafting these papers, so you have to be very alive of that entire process. If it was the disciplinary, you need to remember, was I allowed to come with a fellow employee, or if you are in a labor union, was a representative from the labor present during that time? Was I given reasons why they want to terminate me? Was I given an opportunity to make representations, give my side of the story? So those are the things that really should guide you. And normally the court would look at the process from the beginning of issuing the notice to show cause up to the point when you do the appeal. And the court has to interrogate whether there was fairness in that entire process. So you need to include that. And of course, as I've already mentioned, when at the bottom, at the tail end of it, what are you asking the court to give you?
Okay.
You need to ask that.
Okay.
And there are instances when also the 3-year period, sometimes there are claims that you may need to lodge within 1 year. And the law calls them continuing injury. For instance, if you are underpaid, you don't need to wait for 3 years to lodge a claim for that underpayment. You need to do it within 1 year when it stops, when they stop underpaying you. So if you always have to be vigilant about these claims, because if you don't, then the door is shut and you can't get whatever you want.
Okay.
Yeah.
Mr. Kiche, I'm sure the viewer is wondering, if I was laid off, or if I was unfairly terminated,
Yeah.
or if I've been underpaid for years,
Yeah.
what am I looking at in terms of time?
Yeah.
Because most of the time when people go to court, it's because they're unable to agree.
Yeah.
The employer has probably refused to listen to them.
Yeah.
And they want to know now, if I go to court, even
Yeah.
if I ask for these damages, how long will it take until I'm paid?
Okay.
Yeah, maybe you can just take us through the small process so that a viewer has a general idea of
Yeah.
how long it would take.
Thank you. Sometimes it's a dicey, it's a bit dicey or difficult
Sure.
to answer and place a specific timeline, but perhaps maybe to assist is just to give an outline
Yes.
of what it looks like. So you are aggrieved and you've had your papers ready, you're lodging them into court. Once you do that, you file, whether it is at the magistrate's court or at the employment court. Then once you file, there is what is called summons. This is a document that the court will give you. What it does is now to tell your employer or employee that I have filed this case against you. Now you will be required to respond to it, or you can also choose not to respond. But when you choose to respond, you do it within 21 days.
Okay.
So what the act or what the law has done is to try to reduce the time within which you can do all these things.
Okay.
Because there was the law was changed because the court actually noticed that sometimes they used to take long to deal with those matters.
Yeah.
So in a way to reduce the time, they now require you, when you get the summons, you do your response, your witness statements, and the evidence together within 21 days.
Okay.
Now, if you want your case to be fast-tracked, then it is upon you as the claimant, the person lodging the claim. Once the summons are out and the 21 days period lapses, you now move to court. Tell the court the time has lapsed now. Give me directions on the hearing. Give me a date when I can come and say, I want to be heard on this date.
Yeah.
Because the court will not just move and say that Sian filed the case, we need to hear it. It is you to move the court.
Push it.
And especially, it's important to note, when you're asking for reinstatement, there are instances when the employee might want to be reinstated. So the law also puts a time limit within which you can be reinstated.
Okay.
So what the court has done in most of the cases, if the claimant points that out, then the court will hear that matter on a priority basis. It means it will be given some urgency so that you are not impacted by that 3-year period.
Oh, okay.
Yeah. So if you mention that to court, then the court will list that matter on a matter of priority. So that is something that the employees need to always think about. If you have a reinstatement as a remedy, point it out to the court so that it can be fast-tracked. Yeah, so that really, so I would say from experience, and currently the judges, and because they are magistrates, the cases, if you are vigilant enough, there are cases we can do within a year, or even less. There are some we've done, and we've already gotten the judgment within less than a year.
Wow, that's
so it also
impressive.
it just needs you to be vigilant and proactive as a claimant.
Okay.
Yeah, because normally the employer would call one witness and then you'll also present your evidence.
Sure.
Yeah, but in cases where it is not as complex, the law actually allows you don't need to come and testify, give your oral account. The court will just look at the documents. That is, if both of you agree that judge or the magistrate looking at this, the issue before you, we don't want to come and give our oral account. Everything that we wanted to say is in those documents. So that also fast tracks the process. Yeah.
Okay.
Yeah.
So maybe just to wrap this up, where a person has gone to court and the logical conclusion of the matter has been made.
Yeah.
What should they expect at the end? What should they expect at the end of this process?
So at the end, of course, a judgment will be given. So for instance, if it is in your favor as the employee, then the next thing is to think of how do I now get this monies that the court has given me.
Yes.
So normally you'd start by, you can tell the employer this is the much that have been awarded by the court, and give them time to pay. You can give them 7 days, 14 days, or even 21 days, depending on the circumstances and the amount.
Okay.
Now, that is just being proactive.
Yes.
It's not that the law requires you to do that, but because there was a relationship between the two of you.
Sure.
So once you get this judgment, you can explore that route. Now, the employer might decide not to pay. Then you'll now need to engage an auctioneer.
Okay.
Just to pursue that amount.
All right.
And that of course adds costs even on the employer. So you'll find in cases where the employer is not really aggrieved by the judgment, they would ordinarily pay or ask for a reasonable timelines to pay by installments. Yeah. So you'd get an auctioneer in cases where the employer refuses to pay, or you could also make an application to court to ask that the amounts perhaps in the bank account of the employer to be used to pay the amount that you have been given. So there are avenues that are usually available once you get the judgment, so that you enjoy the fruits of the judgment.
All right.
Yeah.
So that brings us to the end of our broadcast. Mr. Kiche, thank you so much for joining us today.
Thank you.
If the viewer wants to ask any questions, or if they need you to expound on what we've discussed today, how can they reach you?
Well, the viewer can reach me on my work email, which is ikiche@ookladvocates.com. Apart from that, I'm also on LinkedIn as well as Twitter. You can follow me at Isaac Kiche. Yes. Thank you very much.
All right. Well, if you have any questions for us regarding this topic that we've dealt with today, please reach us at info@cyroglobal.com. That's info@cyroglobal.com. Or you can also reach us through our old Gmail address, which is cyrologlobal@gmail.com. We would like to thank Chigiti and Chigiti Advocates for facilitating the shooting of this series, and to our videography team that is responsible for the camera work, the editing, and this great quality that you're watching now. That's Mushiri Frames. We will display the address on your screen. Take care of your families, take care of yourself. Bye-bye. See you next time.